So I already have a process pending with immigration. What about if I apply for this new law? Will that affect my process?
No, it wouldn't affect your current process, and actually it might be important to understand that this is a temporary program. For now, at least, it's scheduled to end in 2 years. We think it might be extended after that, but we don't know for sure. So it would be foolish to terminate a petition that you have filed now that maybe in the future will grant you a green card in preference to filing for protection under the Deferred Action Program, because that's what you get. You get protection from deportation and you get work authorization. But if you filed a petition that will give you a green card and you're just waiting your turn in line, you can keep that petition going too.
I just turned 31 years old in August, and I want to know if I still qualify for that law.
Actually, no. You must be under the age of 31 when the directive was given as a part of President Obama's speech. That was June 15th. So if you reached your 31st birthday before June 15th, you are disqualified. If you reached your 31st birthday after June 15th, that means you were still 30 years old when the directive was given as part of the President's speech, so you do qualify. It's a little tricky. It depends on when you turn 31.
So if I apply for the deferred action, can I still travel inside and outside the country?
Well, the answer is maybe. Certainly you can travel inside the country. As far as traveling outside the country, as we understand it, the program will allow for advanced parole, which means you can travel outside the country and be readmitted in the same status you were when you left. But there's another law that's unrelated to this program that says that if after April 1st of 1997 you have been unlawfully present in the United States for more than 180 days and you leave, you can't come back for 3 years. And if after April 1st of 1997 you've been unlawfully present for more than 1 year and you leave, you can't come back for 10 years. So those kind of people would not want to travel even though they might get permission to travel when they receive their work authorization card.
Okay, thank you.
Mr. Kravitz, I came when I was 11, so do I qualify for this new law?
Yes. Anybody who came to the United States under the age of 16 qualifies for the law. But remember, there are other qualifications. You, first of all, cannot apply for this benefit until you're at least 15 years old. So if you came when you were 11 and you're now 13, you still have 2 more years to wait before you can apply for it.
Okay, yeah, I'm 24, so that's, I have to be younger than 30.
Well, you can't be over 30, which means you cannot have hit your 31st birthday on June 15th, which was the day that the President gave the directive.
Yeah. Okay.
Don't forget, you have to have your high school diploma, too.
That's fine. I have that, too.
Okay, good.
Okay. Do you think, Mr. Kravitz, this is some kind of government plan to deport illegal immigrants?
No, we don't think so. First of all, the government has said that they will not use any of the evidence that is submitted to them as part of this program to deport anybody unless the evidence is fraudulent.
Mm-hmm.
I think it's safe to believe them because this program is very similar to, in some ways with respect to the evidence that they're asking for, to the amnesty program, which was back in the 80s. And millions of people applied for it, and they did not use that information to deport anybody unless it was fraudulent. The reason it's an important question is you, as someone who came here as a child, could qualify for this, could easily qualify for this, and yet have 2 parents living and working here illegally. Mm-hmm. So it's an important question, and it's something that everybody wants to know. And the government is aware of that, and they have said they will not use this kind of information to go after somebody's parents. Okay. We have every reason to believe that's true. It would be counterintuitive for them to do so. It would destroy the program.
Okay, good. And I guess then my parents did not qualify, not qualify, but get any benefits out of
Right, they don't
that.
they're not damaged by it, but they don't get any benefit from it. Now, if this becomes a long-term program and actually turns into what the DREAM Act was intended to be, which was a pathway to permanent residence, then you would be able to get your green card, and after 5 years, like any other permanent resident, get your citizenship. Then you'd file for your parents, and then they would get their residence.
Okay. And I guess I do qualify, so what kind of documents do I need to apply?
Well, okay, good question, because that's going to be different for everybody. It depends how you got here. So if you came with a visa and entered through the airport, that won't be hard. That'll be in your passport. You'll have an I-94 with the date on it. That will establish your entry. We have to prove that you've got a high school diploma, so we want your high school transcripts.
Okay.
And that will show not only that you've got a diploma, but it proves that you were here for each year that you attended high school. We do have to prove a little more than that, because we have to prove 5 years of residence.
Okay.
And since this law began, the clock began ticking on it on June 15th of this year, that means we have to prove that you've been living here since at least June 15th of 2007.
Okay.
So, but if you came here, let's say, when you were under 16 and you went through middle school and high school, then your school records would pretty much establish what we want to show. You were here, number one, and number two, you successfully completed high school.
Right.
You can also, by the way, if you didn't complete high school at the time, you can still qualify for the program by getting a GED, which is a high school equivalency test that you can take.
Okay, good. Thank you.
Sure.
I've been in jail a few times. Do I qualify?
Well, the answer is it depends. It depends on what you were arrested for, or more properly, I should say, what you were convicted of. Basically, the breakdown will be, if you've been convicted of a felony, you probably don't qualify for the program. But certainly not everyone who's been in jail was convicted. Your case may have been one. Also, your case might not be serious enough for it to affect your eligibility for the program. There are 3 categories, as we understand it at this point, with respect to the Deferred Action Program. Felonies, which we think will disqualify the applicant, what they call serious or significant misdemeanors, and there is no specific definition of that, but we know, for example, from our conversations with the government, that a DUI is considered a significant misdemeanor. It may not seem significant, but that's one of the ones that we know that they will consider to be significant. I think it's also probably safe to assume that drug possession, like minor drug possession, marijuana possession for your own private use, for example, is a misdemeanor in most states. But I think the government may consider that to be a significant misdemeanor. The third category is multiple misdemeanors, which we assume they mean to say, well, maybe none of these crimes are serious in and of themselves, but the fact that you have multiple arrests for not particularly serious crimes equals a serious crime, like maybe shoplifting more than once. And I think that what they're talking about is 3 or more misdemeanors of any kind.
Okay, because I have 1 DUI and 1 drug possession.
Well,
I've been in jail 2 times.
Right, but the question is, were you convicted? You've been arrested for a DUI.
Yes.
Of course, so you go to jail because you can't drive home.
Fine, okay. But it was like 10 years ago.
That doesn't really matter. If you were convicted, that that's a significant misdemeanor which disqualifies you from the program. But the fact that you spent the night in jail, that's very common if someone's arrested for DUI. But what happens in court determines whether you're convicted or not. And same thing with the drug possession. If it's simple possession of a small amount of marijuana, it's generally a misdemeanor. We don't really know what the government's position is at this time. But based on the way they treat drug offenses in general, we would have to assume that that would probably be in the category of a significant misdemeanor, which means it would disqualify you.
Because another thing, I have a very high grade. I'm in Miami-Dade College now, but I don't know if it's going to be important.
Not really.
No?
There's no, that's what's called a balancing test, where you say, well, I've done some things poorly and I've done some things well. With respect to the criminal disqualifiers, there's no balancing test. And I think that there may be certain cases where it's unclear whether something is a significant misdemeanor, and they would take into consideration other things in your life. Like, are you a person who is prone to illegal acts? In other words, multiple arrests but no other convictions except that one. Then that's a little bit of a balancing test. She was only convicted once, but she's been arrested 3 or 4 or 5 times. Then I think those things they would take into consideration. But good conduct just by itself does not erase an arrest for a significant crime.
Okay, thank you. I have a deportation letter. I've been here for more than 15 years, and I have a U.S. child. I get married with a U.S. citizen, but I come from Mexico, through Mexico without inspection.
Okay.
Still apply?
Well, there are a lot of different issues there. There's a separate immigration case that will have to do with whether you're deportable or not, and whether your marriage to a U.S. citizen saves you from that, and whether or how your entry into the United States changes your lawyer's strategy on the deportation case. But the fact is, even though the deportation case doesn't disappear based on this law protects you from deportation for as long as it lasts. So you may not be deported if you otherwise qualify for this law. In other words, you entered the country prior to 16, you've resided here for at least since June 15th of 2007, you've got your high school diploma, you're under the age of 30 on June 15th, 2012. If you meet those qualifications, you qualify for the program. So that throws up a wall around you against deportation. You may not be removed from this country during at least the 2 years that this first part of the program will cover. And there may be an extension to the program, and for all we know, it may eventually turn into a permanent law. So the answer is your deportation case will still exist, and there are a number of issues that are relevant about whether you're deportable or not, because of your marriage, because of your entry, and because of your child. But in the meantime, the answer is you may not be deported. You're 100% protected for the next 2 years by this law.
I'm still in high school. Do I need to be graduated?
Yes. Yes, you need to either have your high school diploma, or that could be substituted for by a GED, which is a high school equivalency test that you have to take and pass. You could be honorably discharged from the Army, Navy, Air Force, or Coast Guard. That would also satisfy that qualification of the high school graduation. But if you're in high school, I think the best thing to do is get your diploma.
Okay. Am I going to be able to get a driver's license?
Yes, you'll be able to get a driver's license when you get your work authorization card, which will take several months. some states, and you know, driver's licenses are states' laws. In other words, each state is different and is entitled to make up their own laws about driver's license, including the test you have to take and the age you have to be. And that is, to some extent, true with immigration documents and driver's licenses. So we're not really sure if some states might accept the receipt for filing. That would be great, because when we prepare the application and file it, in a couple weeks we get a receipt back from the government that proves we've filed the application and we paid the fee for the application. If they will then give a driver's license based on that evidence, that's fantastic, because then everybody will know within a few weeks of their application they'll be able to get their license. Otherwise, we're not really sure at this point how long the program's going to take for them to review all the applications completely and issue the work authorization.
Okay, and how long do I have to apply for this new law?
Well, there's no expiration to the program, at least as long as President Obama is still the president. I don't think the program will expire or be changed. It's good for 2 years, but the point is there is no date by which you have to file. I would say that probably the sooner the better, because you'll get your benefits faster. But it doesn't expire unless the law is changed or otherwise modified.
Okay. What will happen to me after 2 years of having this temporary visa?
That's a very good question. We don't know yet. I think that this directive was written with the thought in mind that it would be extended for, if nothing else, it will be extended for an additional 2 years. And they do this sometimes with government programs so they can see the effect of the program and make sure it's working properly and sort of tweak it to see what they can do, maybe to make it better or more efficient. Ultimately, I think it's possible that the program may change into a situation by which you get your green card. For right now, all it is work authorization and protection against deportation for 2 years, with a likely 2-year extension. But we'll see. It could turn out to be a path to permanent residence, and I think if President Obama is reelected, that may very possibly happen.
Okay, thank you.
Sure. We hope the foregoing has been informative, and we think this is an important program, and if you do qualify, or you think you qualify, I think you should look into it. We don't feel like there is a downside. We don't feel like there is a risk that immigration will use this information to damage you or come after your family. We do want to caution people against using notarios, non-lawyers who often charge an exorbitant fee and who are not qualified to represent you in front of the Immigration Service. You may find that your church or charitable organization will supply you with a qualified representative for assistance, but otherwise we think that you should use a trained immigration lawyer to prepare your application. It's a good program. If you qualify, we think you should file. We're here to help. We're happy to help. Let us know if we can help.